that have been won after many years of oppression. Please bear with me. Yeah. Now, in South Africa, the Constitution protects every citizen's right to vote. And then the Constitution then establishes the principle of giving powers to the Electoral Court. Now, the Electoral Court is part of the general court structure in the country. We have the Constitutional Court, which is the highest court in the land, dealing with constitutional matters. Below that, we have the Supreme Court of Appeal, where I am based. And below that is the High Court structure. Now, the Electoral Court, which is an independent court, is part of the High Court structure. Now, I've explained the principles that underpin the operations of that court. Judicial independence and the rule of law. Courts, in particular, electoral courts or all bodies that adjudicate electoral disputes must do that, underpinned by the principles that I have mentioned. Courts must not be afraid to set aside elections that were not fair, free and fair. I'll refer to two cases in particular that came before the South African courts that dealt with elections. In the first case of the Electoral Commission of South Africa versus the Minister of Cooperative Governance and Traditional Affairs, it is cited on the slide. The court in South Africa actually set aside a decision of the IEC, the Independent Electoral Commission, which had decided to postpone an election on the ground that it was not safe because of the pandemic. And the court ruled that the IEC did not have such a power and that it had to ensure that elections do take place on the specified date in terms of the Constitution. Not only that, the IEC had to ensure that people could exercise their right to vote in a safe environment. In other words, the IEC, so the court ruled, had to ensure that all the protocols are in place to ensure that people could vote without compromising their safety. The second case, it's also cited in the slide, Donbella Cortman versus Electoral Commission of South Africa. It's a case which I presided. On 1st November 2021, we had the local government elections in South Africa. And one of the candidates approached the IEC to complain that there had been intimidation at a particular voting station. Having listened to all the evidence and argument, the Electoral Court ruled that the results of that particular ward had to be set aside, and we ordered that there had to be a rerun of the election in that particular ward. So I'm citing these two cases to show that the war against invasion of democracy, against the people's right to vote for the government of their choice, it's something that can be won, something that should be supported. So in South Africa, as things stand, the judiciary is up and running. The judiciary is geared towards protecting the right to vote and ensuring that citizens have the right to free and fair elections. Malawi has got similar protections of political rights in the Constitution, the Section 75, which establishes the Electoral Commission, similar to South Africa. And the Constitution there establishes a commission which has the duty to exercise general direction and supervision over the conduct of every election. In Malawi, I've referred to the fairly recent case of Mutharika and another versus Chilima and another. I'm sure most of you are aware of this case where it was found actually that the elections in choosing the presidency were marred by irregularities, serious irregularities. To give an example, it was discovered that ballots had been T-Pexed out and the voting had been rigged. And the court, they set aside the election of the president and ordered that the election had to be rerun. Now, that case is important in two respects. Firstly, courts should not hesitate to set aside decisions of the independent electoral commissions where it is shown that their decision in declaring results was faulty. The second significance for me that this case highlights is that so-called independent monitoring bodies have got to do their work very carefully. I'm referring to observation teams and so forth. Because what happened in this case is that after the election, the observer teams from all over the world, including the European Union, they rushed to say that they were satisfied that the elections were free and fair, only to find that those elections were later overturned by the court. By the way, this case started in the High Court in Malawi, and then it went right up to the Supreme Court of Appeal, which then affirmed the decision of the High Court in holding that those elections were not free and fair.
Mr. Bruisi, 2 more minutes, please. Thank you.
Thank you. Lastly, Zimbabwe, the constitution there also affirms the citizens' right to free and fair and regular elections, and the constitution establishes the Electoral Commission and provides that it must ensure that the voting method used is simple, accurate, variable, secure, and transparent. What is significant about Zimbabwe is that it has also a specialized electoral court, as in South Africa. Whereas in Malawi, for instance, you don't have a specialized electoral court, but the High Court there is authorized to deal with electoral disputes. In closing, the Electoral Court in South Africa, it has got its own special rules. Now, these are simplified. You know, they are very different to the rules that you'd find in an ordinary high court or any other normal court, so to speak. The rules are simplified so that anybody can be able to access the electoral court and bring a petition. I'm going to leave copies of the Constitution of South Africa and copies of our Electoral Act and the rules to the host. And, you know, if anyone wants to access them, these will be available. These are also available online. And lastly, I have prepared a detailed presentation document. I will leave this with the host, with the organizers, and it will be on the platform. It will be easily accessible. Thank you.
Applause for Mr. Boisier. From Mr. Boisier, we can learn how on South Africa, Malawi, and Zimbabwe established their electoral court, whether it's come from the Election Commission Acts or from the Electoral Acts itself. And the next, Mr. Jean-Philippe de Rozier, the floor is yours. Thank you.
Thank you very much. Good morning again to everyone, to everybody. On this panel on models of electoral justice in Asia, a comparative perspective, I apologize, but I won't speak about electoral justice in Asia, but focus more on the comparative perspective to give some elements about electoral justice in Europe, and in particular in my country, in France, in which we have currently elections. We have two electoral processes. The first is going to take place in the next weeks, the 10th and the 24th of April. It's the presidential election. And in June, 2 months afterwards, we will have the legislative elections for the first chamber of the parliament, the National Assembly, on the 12th and 19th of June of this year. I will structure my brief presentation in 4 points. First, some elements about antecedents, philosophical and theoretical antecedents. Second, the different models of electoral justice in Europe. Third, the case of France, and some conclusive, lastly, remarks about this current presidential election. The electoral justice is a real key point of the democracy, interrogating, questioning who can control the sovereign. If in a democracy the sovereign is the people is electing representatives, persons to act in his name, but to make sure that this representation is effective, someone or an authority, some authority has to supervise, to review that this process is efficient and is operating according to the established rules. Who may have the power to control this electoral process has the power to control the sovereign, because control how the people is delegating his power. So it's a key question of how the democracies are functioning. There are basically two ways to give solution to this question. The first one is considering that the sovereign cannot be controlled and it has to control itself, so that it's the elected authority who will control itself the authority to be representative. And that was the solution given in Europe from the revolutions with what we call the verification of powers, verification of mandates, that the delegated, the elected, control themselves if they have mandates to represent the people. The members of the chambers will control themselves if the others have the mandates to represent the people. Another solution is that we need an independent body, an independent authority, might be a judge or an administrative body, to control the electoral process, with the problem of the separation of power in both of these solutions. Because in the first one, if the sovereign controls itself, then there is nobody that may control the sovereign, which is according to this idea that the sovereign is the supreme power, but there is no separation of power because the same power is controlling its own power. And this may lead to a concentration of power and to tyranny. On the other hand, the other way, the other solution, we have a separate power that is controlling the process, but he's not legitimate by the sovereign to control the sovereign. And then it could turn to be the sovereign himself, to take the power from the sovereign, and then the sovereign is not the people anymore. To give solution to this main and important issue, the way is to introduce a body, an authority, established by the sovereign or by the supreme norm, the constitution, with specific power to control the electoral process, the constitutional judge. This is the other solution that has been implemented in Europe. Today, in Europe, we conserve the two ways. For example, in Germany or in Italy, we still have the model of the verification of mandates, that the parliament is controlling himself the mandates of the different members, or in France, with a judge, the Constitutional Court, we call it the Constitutional Council, that is specifically competent to control the electoral process. The Constitutional Council is competent for the national elections, i.e. the election for the President of the Republic and the two elections of the two chambers of the Parliament, the National Assembly, directly elected by the people, and the Senate, the second chamber, indirectly elected by the people. So let's focus now on the case of France. France introduced the Constitutional Council with the Constitution of the Fifth Republic in 1958. The idea was to control the parliament. So not really to give an independent power over the sovereign, but really to control the parliament according to the political and philosophical background from the founder of this constitution of this Fifth Republic, who is the General de Gaulle. And he wanted to put an end to the almost absolute power of the parliament during the previous regime, the Fifth Republic, in which the National Assembly, the first chamber of the parliament, had the absolute power on the government, and the stability of the regime was really questioned. We had basically in 12 years, more than 20 different governments. So a regime which was really unstable. To put an end to this, we introduce what we call the rationalization of the parliamentarism and some procedures to control the power of the parliament, starting with an independent or external power to review the electoral process. One of the first missions of the Constitutional Council was not to make constitutional review, it was to control the parliament on its competence and on its elections. This is the history of this Constitutional Council. He is also competent to guarantee that the electoral process of the President of the Republic is accurate and operated in accordance to the constitutional rules and the legal rules. But he's not the only authority. We have many different authorities supervising all the electoral process in France. To focus on our current election and the election of the President of the Republic, which is taking place, as I said, right now, we have first the Ministry for Internal Affairs, who is managing the electoral process. He's the one who has decided where are the electoral offices. He's the one who is centralizing all the results, who is transmitting the results to the Constitutional Council. All the administration of the election is provided by the Ministry of Internal Affairs. Second, we have, of course, this Constitutional Council that is supervising all the process and making sure that this process is operating according to the established rules, that the candidates are giving all the elements they have to provide to be candidate, that they have the official signatures to be an effective candidate, and all the formal elements to run for presidency. We have, for the moment, until the election, 12 different candidates for being president. But those two bodies are not the only one. We have also others administrative authorities which are independent. The first one, and probably the most important one, is what we call the CNCCFP, sorry for this acronym, for National Commission for Electoral Accounts and Public Fundings, which is supervising all the finances of the public political parties and for the electoral campaigns. Its power is really important as the regulation on the fundings are very strict in France. An individual cannot give as money as he wants to the candidates or to the political parties, and the candidates cannot go over a certain quote in paying money for their own campaigns, which is 16 million euros for the first term, for the first ballot, and 22 million euros for the second one, for the two candidates who ran for the second ballot. Another authority is the CNCCEP, which is the authority for the electoral campaign for the electoral process for the President of the Republic. And it's supervising the equality and equity between all the candidates. All the candidates are, of course, not equal, because you have one candidate, which is the current president, and he's candidate to its own succession, and others that are candidates from very small parties. To give an example, Emmanuel Macron, I guess you know him, which is our current President of the Republic, has on his Twitter account almost 7 million followers. If you take another candidate, for example, Jean Lassalle, and I'm sure here no one knows him, he has 1, 2, 3,000 followers. So if Emmanuel Macron says something on Twitter, everyone will know it. If Jean Lassalle says something on Twitter, perhaps if you have chance, you will notice it. And that gave the opportunity, and I will conclude my speech with this case, give the opportunity to this CNCC-EP, this administrative authority supervising the equality between the candidates, to make a very questionable statement. Emmanuel Macron declared his candidature on his Twitter account, on his personal Twitter account, this one followed by more than 7 million people. This Twitter account, it's once again personally dedicated to Emmanuel Macron. I guess Emmanuel Macron is not like Donald Trump and he's not tweeting by himself. There is a team tweeting for him, but the name is Emmanuel Macron. It's not the Twitter account of the Presidency of the Republic. It's its personal one. And this authority asked Macron to take over this declaration, considering that this account was dedicated to the President of the Republic. And in the last 5 years, it was basically dedicated to the action of the President of the Republic, which is normal because he is President of the Republic. But this authority considered that it's unequal for the other candidates that he can put his declaration on this account when the other cannot, because they are not President of the Republic. But this is, in my opinion, very questionable. First, because this authority doesn't have the competence to do so. There is no statutes giving and regulating the electoral campaign on the internet in France, which is probably a problem that we have to provide a solution to this. But there is no regulation on the electoral process on internet, on the social networks, on Facebook, on Twitter, on Instagram, and so on. So this administrative body doesn't have the competence to do so. Second, if you allow a president in charge to be candidate to its own succession, why would you forbid him to put its candidature declaration on his personal account? If that were on the official account of the Presidency of the Republic, then that would be a problem. But if it's on its personal account, and if he's allowed it by the Constitution, by the law, by the legal rules to be candidate to its own succession, then I don't see where there would be a problem that he puts its statement of candidature on his personal Twitter account. This leads to first element of conclusion that, and we will probably talk about it this afternoon, the technology, the digital, the social network, the internet in general, has to be ruled now for electoral campaign, which is not the case in France, and it's very problematic because there are rules for the speech on the radio, on the television, but not on YouTube. And today we are all still watching TV, but we are all also watching a lot on YouTube, also watching a lot on Facebook, on Twitter, on Instagram, and on other social network I even don't know. And there is no regulation on this. There is no regulation about the time you spend on this social network. That's the first element. A second element, it's that it seems very problematic that this division of the authorities supervising the elections are not, they have no coherence together, and that this authority I mentioned, the CNCCEP, which is supervising and reviewing the equality between the candidates, can make such a statement without any legal background and any competence to do so. And its decision, which actually is not mandatory, but its decision first has been followed by the president. I don't think he needs that to make sure that everyone knows that he's candidate. But its decision is not repealed by any other body. And this is probably problematic for the accuracy of the electoral process. So let's see what happens in the couple of next weeks after the election of the President of the Republic on April 24th. The Constitutional Council will be the body who will make the proclamation of the results and review all the process. He's the body in front of whom the election can be questioned and perhaps repealed, even if this never happened until now. Thank you very much.
Thank you, Mr. Jan. A round of applause for Mr. Jan. Ladies and gentlemen, we learned a lot from France, Malawi, Zimbabwe, and even South Africa about on how to conduct the electoral justice around the world. But I please share the floor with all the participants who might be able to give some more insight about on how the electoral justice were settled, not only in our own respective country or maybe in another experience. The floor is shared. You may guess. Yes, Mr. Fritz.
Thank you. Thank you for Justice Boshier and Jan Phillips that already shared his idea. I have two questions. The first first to Justice Boshier, and it seems like for me that there is like fighting competence between the Supreme Court and the Electoral Court or the NEC. It seems like the Supreme Court is not give the independence about the Electoral Court or the national elections. And is that my understanding is correct about what happened in South Africa and also Malawi and also in Zimbabwe? Or the Supreme Court is happy when they establish the Electoral Court, like some of their burden is already lift off and now give to the Electoral Court, or the Supreme Court is not really want to give or release to share the authorities with the Electoral Court? Yes, my first question to Justice Boshier. And my second question to Jan Phillips about in Indonesia we have three organizations that involved in the election. First is the Bawaslu as the election supervisory board. The second is the election commission, National Election Commission that doing the election, and the third is the Honorary Ethical Council that observe the all the behavior, the ethical behavior from the election and also supervisory board. Many people say that it's too much, just give only one body. But when I heard your presentations, it seems like you have more than 3 or 4 organizations, and how that mechanism works. I mean, how everybody exercise their competence without overstep other organization or other authorities. Thank you.
Thank you, Mr. Fritz. Can I have another one, please? Okay, Mr. Ro.
Thank you, Mr. Chairman. I wonder if we could go a little bit deeper in terms of relation between the electoral justice and the organization of elections. I discussed a few years ago with some friends from Holland, and he asked me quite naively, say, "Well, I don't know why you have to dig into that. In our country, we vote, we count, and we don't need any judge to establish the counting. We accept the counting from the EMB." So it means one thing. It means that the whole idea of the EMB and the electoral justice came from one crucial problem, is the trust you have on the result. So if you can control the trust, and I have the feeling that because the electoral process is now more and more complex, you have more involvement of money, you have more involvement of technology, you have more involvement of the what they call the primaries among the candidates. So all of this debate and all of this dispute will go to the court, because the organization of elections cannot handle that anymore. That's why it's it's complex to see how the electoral justice is following closely the evolution of the electoral management itself. So in many cases, and then we will go back to that later, but in many cases, we cannot treat the electoral management process as something independent, and then the judges and the magistrate invent a few things around the elections to give them some power. That's also the critics we receive now in our region, saying that the judge are not elected, and then they will go to decide even constitutional issues. For example, the discussion on the freedom of speech during the campaign is part of this understanding that where are we in terms of the protection of fundamental right by the Constitutional Court. So that's my let's say the suggestion that we can dig it a little bit more between these two, the evolution of the elections and the evolution of the electoral justice. Thank you.
Thank you, Mr. Zong. I believe Mr. Bozier and Mr. Jan will be pleased to answer the questions that. Oh, we have another one. Please, Mr. Aditya.
Okay, thank you very much for your presentation. Actually, I'm interested to know about, we call it as the deterrent effect mechanism. Could you explain to us in your cases in what way we can understand the deterrent effect mechanism can effectively efficient to the candidates, to the electoral management bodies, officer, or something else? So because in Indonesian case, I think we still have some problems to what kind of effect that perhaps they can make it some. We don't want to make it manipulation again. We don't want to make some unusual things and something like that. So can you explain is there any some deterrent effect that perhaps we can understand from this from your case? Thank you.
Okay, the last maybe Mr. Ferry. Thank you.
Thank you, Mr. Purnomo. In our first three speaker, it seemed for me most of the speaker talk about the problem of democracy in several countries. And it seems a lot of symptoms that they explain. And the second part of the current speaker talking about how important the court as the cure of that symptoms. In my perspective, probably in Indonesia, it's not like that, because the court also part of problem in Indonesian election. That's why I'm not really agree when Mr. Fritz asking about comparing EMB with the justice or judicial system in your both countries, because totally is different, and we cannot compare electoral management body with the judicial system. In Indonesia, a lot of problem. We also do have a lot of dispute doors, not only with the judicial system, but also with Bawaslu and also administrative court. And it seems in that situation, France experience probably need to explain how in France they manage to separate three, I think you have three different courts, is it, in your country? There's a Supreme Court, Administrative Court, and also, I think, Criminal Court. And do you have also Constitutional Council? And I think it's interesting if you can explain how they can separate the power. Thank you.
Wow. Okay, Mr. Jean and Mr. Boise, we have 4 questions from Mr. Fritz, Mr. Dong, Mr. Aditya, and last but not least, Mr. Ferry Amsari. The floor is for Mr. Boisier first, please. Thank you.
Thank you. Very interesting questions. There is increased criticism on the aspect of the judiciary having a role, and in fact, a decisive role in as far as the elections are concerned. Rightly, the criticism spans from the idea that judges are not elected, whereas electoral bodies like the independent commissions are elected and operate directly as at the wish of the populace, to coin an easier phrase. But I want to emphasize that as far as the courts are concerned, ideally, they should not intervene. The body that is set up to run elections, it has got to do so in terms of its clear and legislated mandate to ensure that elections are run properly, to ensure that the government that is put in place, it's there because it is the choice and the will of the people. That is the primary role of the body that is there to run the election. Now, in South Africa, for instance, we have the Independent Electoral Commission. It's governed by an act of parliament. There are rules on how it should conduct its business. It's got to do voter education. It has got to ensure that political parties, contestants are properly registered. It has got to ensure that there's fair play during elections. It has got to ensure that there is no intimidation, there's no undue influence of the voters, and most importantly, ensure that the voting public are able, or is able rather, to exercise its right to vote. The IEC in South Africa, for instance, has got a mediative role. So all disputes, that's where they start. And it has got the power to resolve all the disputes that come before it arising out of the elections. So in other words, that is the first port of call. If anybody is unhappy with how the election has been conducted, the first port of call, you go to the independent commission, and the independent commission has got a duty to resolve that. It's only where a party or a petitioner is unhappy with the decision. It's only in those circumstances that the party must then approach the electoral court. And in the case of the electoral court of South Africa, there are many cases which have come before the court and which have been rejected on the basis that, look, you have not exhausted the internal procedures. You have not first gone to the independent commission where you were supposed to start. So I'm emphasizing the point that the relationship between the courts and the commissions, that relationship has got to be approached from that basis. Ideally, there should be no reference to the court. It's only in cases where there's been a clear dissatisfaction where a party can then come to the court to review the decision of the election commission. The primary role of the electoral court in South Africa, for instance, is to review the decision of the electoral commission. So the relationship between the court and the electoral commission has to be viewed in that light. I think that applies across the board. Which leads me now to the first question about the relationship or the operational aspects between the Supreme Court, the Constitutional Court, the Supreme Court, and the Electoral Court. One must understand that courts, the system of our courts in South Africa and in many other countries in Africa, they are based on what is called a court hierarchy. That is, we have at base level the High Court and the Electoral Court. These are all on the same level. So if a litigant has exhausted the procedures at the commission level, you petition the Electoral Court, which is on the same level as the High Court. Now, that court consists of 5 members. If you are still unhappy with the decision of the Electoral Court, then you can go higher to the Supreme Court. The Supreme Court, which is the higher body, it can set aside the decision of the lower court, that is the High Court, and or the Electoral Court. That is the next level, the Supreme Court of Appeal. But then, if the matter has got a constitutional, obviously, the right to vote, it is a political issue, it is a constitutional issue. You can then take that right up to the Constitutional Court. I've referred you to the case of Mutharika in Malawi. That was decided, that went ultimately to the Supreme Court in Malawi. I've referred to the case that happened in South Africa, which was settled by the Constitutional Court. So there's no disjoint between the Constitutional Court, the Supreme Court, and the lower court. We are only here talking about the hierarchy. A matter starts from the lowest court, it can go right up to the highest court. And once the highest court has pronounced on the matter, that is the end of the matter, and that is binding on all the lower courts, on all the lower structures.
Yeah.
I hope I've answered that question.
Thank you, Mr. Bose. Mr. Zhang?
Thank you. I have a couple of hours to answer all the questions.
5 minutes max, please.
I will start from important element that Dr. Dong mentioned, the trust. The trust in the electoral process, the trust in the electoral result, the trust in the electoral justice, the trust in the democracy, the trust in the institutions of the democracy. But the problem of the trust, which is, as you see, the key point, is that you cannot state trust, half trust. You cannot say that. Or you can say it, but that doesn't imply that the person in front of you will have trust. You have to inspire trust. Mm-hmm. And inspiring trust is a question of cultures. I will take one example of two different cultures. One example of a country which is here represented, Brazil, of my friend Michael, and Europe in general and France in particular. In Brazil, the digital vote is generalized. Everywhere in Brazil, you vote digitally. And this is an element of trust, because electors consider that because it's digital, you cannot manipulate it. It's trustful. It's in the machine and it's secured. In France, the digital vote is present in 60 municipalities. We have 35,000 municipalities. Just so to say that it's something very, very rare. And the digital vote is considered as something you can manipulate. It's not secured. In the contrary, the paper vote, the traditional one, this one is trustful because you can see it. You have the paper, you can count it, recount it, and you see when it gets from the hand to the box, which is transparent, and this is trustful. It's not to say that one solution is better than the other. It's a matter of culture. It's a matter of culture. In one culture, digital is considered trustful. In another, the paper is considered trustful. And that leads me to some questions that I try to summarize with our differences and similarities. Yes, in France, we have many different bodies that are involved in the electoral process. I mentioned the Ministry for Internal Affairs, I mentioned the Constitutional Council, I mentioned two of the administrative authorities. Actually, we have more than just two that are operating in their competences. We have one for the radio and the television as well. So there are numerous. The authority which is supervising the elections for the President of the Republic, all the process is the Constitutional Council. And some of the decisions of the other authorities can be reviewed by the Constitutional Council. You have possibility of appeal in front of the Constitutional Council. Not all of them. Some others can be reviewed by the Supreme Court of Administrative Justice. It's called the Council of State, State Council. And yes, actually, as a colleague said, we have 3, or let's say 2+1 judiciary bodies, one competent for the administrative matters, another for all the civil and criminal matters, and we have the Constitutional Council, which is not a Supreme Court, as the Supreme Court of the United States, because it's only competent in the constitutional affairs and the national elections. But for the local elections, it's another body, it's the Supreme Court of Administrative Matters. So yes, it's quite splitted, but it's a question of culture. It's a question of culture that it has been so implemented in France for some of the reasons I mentioned in my presentation before, to rationalize the parliamentarism, to control the power of the parliament, to control the power of the local assemblies with different histories and different backgrounds. Then to provide always more supervision, checks and balances, reviewing processes of the electoral process. Some other authorities has been introduced, such as the one on the electoral campaign account and funding of public funding, such as the one competent for the equality between the candidates. And indeed, we are missing a centralized process that can review all the elements. But I will end with a question. I don't really have the answer. I don't know if French people will trust in a new organ that will concentrate all the power and supervise all the process. Because if there is only one, there is no control on this only one. And it can be questioned on the concentration of its power. And this is also a question of culture.
A round of applause for Mr. Boisier and Mr. Zhang. And ladies and gentlemen, I've got to end these sessions. We've got a lot of reference about on how the electoral justice were conducted, at least for now, on 3 countries in Africa and on France. And I'm sorry, Mr. Segundo, maybe I hope that this could be an opportunity for us to use the lunch sessions or the snack sessions to discuss furthermore about the electoral justice. I'm Purnomo, signing out. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Okay. Thank you for Mr. Purnomo. Then thank you for this session. Now we will take a break for lunch until 2 p.m. and lunch will be held on Gading Resto in VIP session. Then, ladies and gentlemen, we inform you that for administration part, please collect a document like boarding pass, PCR receipt, and another administration matter to the registration area in front of ballroom. Thank you.
So the lunch place is near with this place. So just going out and we move to that part. See you. Thank you. Thank you, Jeff. Yes. Pak.
Recording stopped.